groundbreaking and important work. So I'm going to start with introductions. First of all, Ms. Bannon is the Managing Director of the Democracy Program at the Brennan Center for Justice. Professor Levy is the Professor of Law at Duke Law School and Faculty Advisor to the Bolch Judicial Institute at Duke. Professor Littman is an Assistant Professor of Law at Michigan Law School. Professor Root Martinez is a Professor of Law at Notre Dame Law School and the Director of Program on Ethics, Compliance, and Inclusion at Notre Dame. And Ms. Shaw is an Associate at Kecker Van Nest and Peters and the co-founder of Law Clerks for Workplace Accountability. So a few housekeeping things first. You can drop questions into the chat and we will try to incorporate those organically throughout the discussion. We would love to have audience questions to put into this conversation. And then I want to turn to our panelists to give a brief overview of the essays that they wrote. And I'm going to start with Professor Littman and Ms. Shaw. If you could take a few minutes to talk about your piece.
Of course. So first, thank you so much for organizing this panel and also organizing this series of essays. It was a wonderful idea, and it's truly a delight to be in such terrific company. Because this is a webinar format and Diva and I co-wrote the essay, I'm going to spend like 2.5 minutes talking about the problem that we were trying to address in the essay, and then Diva is going to turn more toward, what we see as some potential solutions. So the essay that Diva and I wrote is about the problem of harassment in the courts. And while Diva and I are primarily focused on sexual harassment, I think a related concern that we haven't talked as much about but is equally important is the problem of abusive working environments within the courts as well, in addition to sexual harassment. Sometimes these things are related, and the judiciary has something like 30,000 employees, including people, law clerks, who are at the very beginning of their careers, who may lack prior work experience or professional connections or colleagues to help extricate themselves from or just deal with a dysfunctional work environment. So I wanted to talk about 3 attributes of the judiciary that make it an environment where sexual harassment or other forms of abusive work environments can occur. The first is just the fact that federal courthouses are rather isolated and operate with considerable secrecy. Obviously, in order for the courts to function, they need to keep a lot of their business secret, and clerks and other employees have obligations of confidentiality that prevent them from talking to other people about what might be happening in their workplaces. The workplaces are also pretty decentralized. Every courthouse, every chambers works a bit differently, and they might not be all connected to one another. The second issue is really the problem of power dynamics in an environment that is not particularly diverse. What this means is that no one really has an incentive to challenge federal judges when they behave inappropriately. Instead, people have the incentives not to do anything or to say anything. Clerkships and working in the federal courts are shiny objects, and law firms treat them as such, as do public interest organizations, nonprofits, and jobs later on down the road, like academia. Law schools also have an incentive to maintain good relationships with judges because they want to be able to get their students into clerkships. And finally, anyone who has clerked for a federal judge has an incentive for people to think that that clerkship and that judge is a good judge and that it's a good clerkship. You want your clerkship and your judge to be regarded as a good one that will help people advance professionally. And sometimes, we will hear the metaphor about how clerkships or clerk networks are like families. And all of that creates, these network effects where people are invested in deferring to judges, having good relationships with judges, and kind of papering over what might be less than ideal work environments. The third and final contributing factor we talk about in the paper is the problem of gatekeepers. The reality of clerkships is we treat judges as gatekeepers. We defer to their judgments about their employees, and that can affect someone's career prospects later on down the road. Sometimes professors also act as gatekeepers to get people into clerkships, and giving that much power to any one person just isn't a great system because it creates the potential for abuse. So that's a quick rattling through of some some of the contributing causes that Diva and I talk about in the essay as to why the federal courts might have structurally a problem of harassment. One quick thing before I pass it over to Diva, and here I just want to say I'm speaking only for myself. It was a joy to work with Diva, but I don't want to saddle her with any of the weird or crazy things that I might say. There is this tendency, I think, which I think social media has enforced, to think that everyone in the legal profession, or at least the legal academy, is ostensibly against harassment and thinks harassment is a bad thing. But I think that's actually pretty different from living in a world where everyone in the legal profession or the legal academy thinks they have an individual responsibility to do something or to say something when they observe or hear about behavior that should raise red flags, whether it's about misogyny, racism, abuse, harassment, or anything else. And in fact, if I've learned anything from this piece, it's that people don't really like it when you suggest that maybe we all, including them, can and should do something about the harassment that has existed in our profession, including in the federal courts. And with that, I'll pass it over to Diva.
Thank you so much, Leah. And it's truly an honor to be here with many of these women that I really look up to, and I've loved reading your pieces. So I'm very excited to discuss your pieces. What I'll talk about here is stuff that's not necessarily in the essay that Leah and I wrote, but changes that we would propose, and some of those are in the essay and some are not. But I'll start first with sort of concrete solutions that we're hoping that either Congress will put into place or that the judiciary would push for itself based on some of the issues that Leah just mentioned. So Leah and I would recommend that there be regularly conducted climate surveys of workplace culture to determine the effectiveness of the judicial branch's policies that are designated to prevent and remedy harassment. Here, that doesn't happen all the time. It definitely does not happen on a national level. And without that kind of information, it is difficult to understand whether the policies are working for the people that they're intended to work for. The other change that we would recommend is ensuring some type of protection for whistleblowers, prohibiting retaliation against them and providing them with the right to sue if they are retaliated against, so that more people feel comfortable coming forward if they've dealt with harassment or abusive conduct during either their clerkships or while working for the judiciary in other capacities. One thing I'll note here is that although our paper focuses on clerkships, the policies that we're talking about and the types of harassment that can occur don't just affect clerks, they affect any employees of the judiciary. And also, this was a surprise to a lot of people, but public defenders' offices, for example, also fall under the same umbrella. And so protecting whistleblowers goes farther than just the clerk relationship, would help people report on a broader level. One of the larger changes Leah and I would recommend also is ensuring that employees are protected by federal laws that prohibit discrimination based on race, color, religion, sex, including sexual orientation and gender identity, national origin, age, and disability. We'd want to ensure that the judicial branch's employees are protected by the procedures that we all take for granted in other places, such as Title VII and the ADA. And it can be a surprise to many people whether those statutes apply in the judiciary context, and they don't. Another change that we would also recommend is a nationwide confidential reporting system, an actual fulsome confidential process where people can feel comfortable asking questions. There's a hotline for covered employees to discuss sort of whether they should come forward, what the repercussions might be if they come forward, what protections they have against retaliation so that they fully understand these issues. And then we would also suggest reports from the judicial branch to Congress about workplace discrimination, judicial misconduct, whistleblower complaints, and also information about the demographics, both of the staff and all of the employees of the judiciary, but also for clerks, because as our piece discusses, some of these problems are particularly an issue for first-generation students who go on to clerk, for women of color and people of color, and for individuals who may not have access to the same systems that other people may have had before they start their clerkship. So those are the sort of concrete changes. One other concrete change before I forget is just that federal law should hopefully apply to everyone who was a judge at the time of their misconduct when it is alleged in a complaint, regardless of whether the judge resigns, retires, or is deceased. And some of the changes have in ways become a part of the Judicial Conduct and Disability Act, but we think that there are more changes that could be made, whether the judiciary puts those into place or Congress has to. I think is a discussion that we're looking forward to having and a discussion we should be having. In terms of non-concrete steps or sort of cultural changes, those are a little bit harder to talk about. And I'll start first by saying I absolutely agree with Leah about individual responsibility, because it is difficult to talk to people about the individual roles that all of us play, including myself, including law professors, including people who work for the judiciary and judges themselves, in sort of allowing these sort of power dynamics to thrive and these issues to continue, even if you are not actively yourself engaging in misconduct, or if you are not actively recommending people to clerk for someone that you know engages in misconduct. There are other individual responsibilities that people have to not just calling out that misconduct, but figuring out why the systems continue to work in this way. One of the ways to change those norms is to speak up when you see these kinds of things happen, but that can be very difficult in a profession that is not necessarily premised on speaking up. What can happen instead if these changes don't happen is that certain people are relegated to being the individuals who speak up on these actions. That takes away, and I'll cite to actually Professor Ruth Martinez's work on this, that when certain groups of people who tend to be women and people of color speak up about these issues, that's the role that they get relegated to. It makes it harder for them to do their work on a regular basis. And it also means that people are less likely to listen when the same people continue to speak up. And so changing the culture of the judiciary and the culture of our profession, culture of law schools and how they think about clerkships is a longer term goal, and one where law schools also can play a stronger role, not just on the ground and with individual students, but also with working together with the judiciary and thinking about what role they can play. But changing those norms might seem hard, but it's not that hard if everyone can take a little bit more individual responsibility to think about what role they could play in changing these cultural issues.
Thanks to both of you for introducing your essay, and for audience members who haven't had a chance to read their piece. It's titled On Sexual Harassment in the Judiciary, and I really recommend taking a look at that. I want to go to Professor Ruth Martinez now. That's a good transition, a good segue into her essay, Avoiding Judicial Discipline.
Thank you so much. I really want to say a special thank you to Northwestern Law Review and the editors, because this collection of essays was their idea, and I'm just so honored that I was approached to work on this project. And I really think that it's an important one, and that it's going to be one that bears fruit in a variety of ways. I think we might see some congressional action, and I think it's just great that this collection has been published by the Law Review. And it was just a pleasure working with everyone. So over the past several years, several high-profile complaints have been levied against Article III judges alleging improper conduct. Many of these complaints, however, were dismissed without investigation after the judge in question removed themselves from the jurisdiction of the circuit's judicial council, oftentimes through retirement and once through elevation to the Supreme Court. But what happens when judges, the literal arbiters of justice within American society, are able to elude oversight of their own potential misconduct? Judges are essential to the belief in and adherence to the principle and belief in the rule of law, and play an integral role in the democratic ideals of freedom and justice. So recognizing the important role judges play within the key functions of American society, certain safeguards have been put in place to ensure that concerns regarding allegations of judicial misconduct are addressed. My essay, Avoiding Judicial Discipline, focuses on one such safeguard, the Judicial Council's Reform in Judicial Conduct and Disability Act of 1980. So let's call it the Judicial Conduct and Disability Act, which governs concerns regarding the conduct or disability of federal judges. The act has enabled the judiciary, through its own self-oversight and governance, to address allegations of improper conduct or disability of judges as they arise. On the one hand, there are judges who have engaged in irregular conduct and are subsequently found to be suffering from physical or mental illness. In these instances, the Act allows for a dignified and oftentimes private resolution to the matter by the chief judge of the circuit seeking retirement of the judge, often on the basis of disability. But on the other hand, there have been judges who have engaged in outrageous, improper behavior, who have been publicly reprimanded and disciplined by their colleagues via the circuit's judicial council. My essay focuses on a narrow question under the Act, which falls somewhere in between the above those two situations. What happens, or perhaps what should happen, when allegations of improper conduct are levied against a judge, but the judge leaves the court prior to a full inquiry? Currently, under the Judicial Conduct and Disability Act, formal complaints regarding the conduct of Article III judges are referred to the chief judge of the circuit court where the judge holds office. In a typical matter, the chief judge, sorry, my children are doing a lot of movement. So in a typical matter, the chief judge of the circuit opens an inquiry, investigates the merits of the complaint, and the chief judge or the judicial council concludes with a decision. The Act's mandate, however, applies only to current judges, which has resulted in some judges stepping down from the bench after a complaint is levied against them. As the Second Circuit Judicial Council explained, the Act is, and this is a quote, the Act is concerned with individuals who currently exercise the powers of the office of federal judge. Its emphasis is on correction of conditions that interfere with the effective and expeditious administration of the business of the courts. Because the now former judge fully resigned the office of United States Circuit Judge and can no longer perform any judicial duties, the former judge does not fall within the scope of persons who can be investigated under the Act. So in other words, a complaint has been levied, the judge removes himself from the court, and then the investigation is stalled. So in recent years, several investigations into the conduct of Article III judges have been cut short when the judges left the court before the Judicial Council concluded its work. This limitation of the Act is problematic for a variety of reasons, in my view, but in part because it allows judges to avoid judgment. The people we ask to assist us in making decisions about whether or not things are functioning appropriately under the law are dodging their own, they're dodging investigations into their own potential misconduct. So this essay argues in favor of mechanisms that will ensure investigations into judicial misconduct are completed, even in the event that the individual is no longer serving as a judge or serving as a judge subject to the Act's mandate. It relies upon literature exploring legitimacy and the courts to explain why a lack of robust oversight and investigation into complaints regarding members of the judiciary may delegitimize rule of law norms that are necessary to the proper functioning of the United States. The essay puts forth two proposals. And it does so with the recognition that congressional action right now can be challenging. So the best alternative would be to amend the Act so that investigations can continue even if the judge is no longer on the court. That would be ideal. But assuming that that ideal cannot be achieved, the second proposal is to create a custom of automatic referrals regarding the need for an investigation into a judge's conduct from the Judicial Council to the state bars for which the judge is a member and to Congress. So let's assume that a judge has been removed, a judge has left the court and is no longer under the authority of the jurisdiction of the Judicial Council. Assuming that judge is an attorney and is a member of a state bar associate and a member of a state bar, the state bar can issue its own investigation into that judge's potential misconduct and determine whether or not it warrants any sort of sanction from the bar. And so there is still some sort of mechanism in which the judge could receive some sort of sanction or reprimand or something, or some sort of mechanism in which an investigation can occur and potentially be the results of which could potentially be provided to the public. Or you could refer this to Congress for impeachment proceedings. Again, impeachment proceedings like acts of Congress are not often pursued, but it is worth, I think, sending something to Congress so that they have to at least make a decision on whether or not an investigation should go on. I'm going to stop there, just in light of timing concerns, but I look forward to our conversation.
Thanks, Professor Martinez. I'm going to shift a little bit now to Professor Levy and her piece called The Promise of Senior Judges, and thinking about what reform opportunities might be available if the bigger reforms are sort of out of reach.
Wonderful. Well, thank you so much, Sarah. Thank you also to Adam, Emily, Greg, Kevin, and all the other truly outstanding editors at the Northwestern University Law Review. It was, needless to say, a privilege to publish with you all and alongside this extraordinary group of scholars. So my essay, The Promise of Senior Judges, begins with a question. What is the ideal size of the federal courts of appeals? And specifically, how many judges should there be, and upon how many different benches should they sit? And what would seem like a straightforward set of questions has actually confounded Congress, judges, and scholars since nearly the time that the modern day courts of appeals were created in 1891. So just by way of brief history, the federal appellate courts began with only 9 circuits and just 19 judges. It's hard to believe, right? So over the next 90 years, 4 more circuits were added. So we got the 10th, 11th, DC, and federal circuits to take the total to 13. And then over the next 100 years, again, from the starting point of 1891, 160 judges were added to take the total to 179. So why did Congress expand the courts of appeals, indeed dozens of times, for the first century that those courts were created? Well, the answer is to attempt to keep pace with a caseload that was expanding at an even faster rate. So again, by way of history, in 1892, this was just 1 year after the courts were formed, there was an average of 44 filings per judgeship per year. So by 1950, that figure had nearly doubled, so that the learned hands of the world were hearing about 73 cases on average per year, even while the number of judgeships had grown from 19 to 75. That figure then more than tripled in the next 40 years to 237 filings per judgeship in 1990. And this was as even more than 100 new judgeships had been authorized. For reasons concerning politics, Congress has not added a new seat to the courts of appeals since that time, right? So in the last 30 years. But the caseload has not stopped growing just because Congress has not continued to grow the judiciary. In fact, according to the most recent statistics provided by the Administrative Office of the U.S. Courts, the number of filings per judgeship is 20% above where it stood in 1990. So a straightforward solution to this problem would be to have Congress simply authorize new judgeships. And I think for the first time in a long time, there is reason to be optimistic that Congress will do so. And in fact, they had a hearing on this very subject just a few weeks ago. But as we do not yet know when Congress will act, and as we do not know when Congress's actions would take effect, as there's talk that Congress would stagger the creation of any new judgeships at this point, then I think we have to ask ourselves the following. Right, so if the answer to our earlier question about the ideal size of the federal courts is bigger than it currently is, what are the courts to do in the meantime? So my response, as I argue in the essay, is that some relief, at least, can be found in further incentivizing judges to take senior status at this time. So very briefly, as I'm sure many here know, senior judges are a special class of judges who have left regular active service. This is after they have reached the age of 65, and the years of their service plus their age has totaled or exceeds the number of 80. This is the so-called rule of 80. And the thought is they're still able to decide cases on their own courts. So taking senior status, as you can appreciate, functions as a kind of quasi-retirement, but it still permits judges to hear cases, just often at a somewhat reduced load. So judges, again, could hear, say, 50% or 75% of an active judge's caseload. But perhaps the most important point here is that by assuming senior status, each judge also then creates a vacancy to be filled by a new active judge. And so the basic intuition here is that if there were enough judges who could today take senior status, and if there were enough incentives that could be created for taking senior status, then we collectively could create, at least temporarily, more judge power for the courts of appeals. And again, briefly, I will just say it turns out happily that there are enough of each. So when I wrote the essay, there were over 60 judges. So we're talking about a third of the current size of the courts of appeals, right, who are eligible to take senior status. And based on terrific work that we've seen done by Professor Steve Burbank at Penn and a few of his co-authors, we know some of the factors that judges have considered in the past when deciding whether or not to take senior status. right? So the kinds of considerations that come into play, right? They think about losing the ability to preside at panels, and with it, the loss of opinion assignment. Right? They worry about potentially losing chambers, right? Having to give them up. They worry about a loss in general status, right? Feeling lesser than their active colleagues. So one of the main contributions of this essay, and it's based on interviews that Judge John Newman of the Second Circuit and I conducted of all of the current chief judges of the federal courts of appeals, and surveys that we put out to all current clerks of court, right, is how senior judges are actually treated in each circuit. And what we learned, and as the essay documents, is that there's significant variation in the treatment of senior judges along these dimensions. So just briefly, in some circuits, a senior judge might in fact have to give up his or her main chambers or visiting chambers. They might be relegated to the end of the bench at ceremonial functions. They might not be permitted to vote at court meetings on administrative matters like local rules, right? Whereas in others, senior judges are actually given their first choice of opinion assignments coming out of a sitting. They are promised that they're going to retain their chambers, and they are treated generally in the order of true seniority, meaning that they are treated based upon their commission date. Right? And so the essay concludes by recommending that all of the circuits move towards adopting more senior favorable policies in the hopes of encouraging more judges to take senior status at this moment, again, to increase the judge power of the courts of appeals. And I would just say, I think the larger point is that as we consider some of these bigger structural reforms, we should not lose sight of the smaller norm-based interventions that can also assist the judiciary, particularly as we wait on Congress for hopefully what will be some larger changes to come. Thank you.
Thanks, Professor Levy. And now I'm going to go to Ms. Bannon, the author of our last piece, which is not yet published, but will be in about a month or so. The title of her piece is Remote Court, Principles for Virtual Proceedings During the COVID-19 Pandemic and Beyond. So really zooming in now to reforms that were made not because of human intervention, but because of circumstances outside of our control.
Thank you so much for including me. I just want to say it really has been such a joy working with the Law Review, and it is really a delight and honor to have the opportunity to participate in this panel today. And this is a piece that I'm co-authoring with a Brennan Center colleague of mine, Douglas Keith, who is on parental leave, so he's not able to join us here today. So I'll do my best to cover the full gamut of our work. As Sarah said, I'm Alicia Bannon. I work in the Brennan Center's democracy program, focusing on fair courts issues. And so, through that work, we do a lot of work with judges and advocates around issues of access to justice. And so the genesis of this piece was really the fact that, when COVID struck, when courts had to adapt very quickly and were kind of building the plane as they were flying it, we saw, a remarkable and surprisingly quick adjustment in a lot of jurisdictions around the country to heavy reliance on remote proceedings. And that has been embraced by many judges as revelatory and suggested that this is, the courts will never be the same. This is, a new reality, and this has kind of been the shock to the system that the judiciary needed. And at the same time, in a lot of conversations that we've been having with legal services providers and other people who were kind of in the trenches in particularly kind of the so-called poor people's courts, where so many people actually touch our justice system, the story was far more equivocal. And particularly in light of the fact that there seems to be strong signaling from many chief justices and others within the judicial system that remote courts is not a pandemic experiment, that this is being viewed as potentially a much larger sea change in how at least certain court proceedings are done. We thought it was important to kind of dig into what we were hearing from individual advocates on the ground and kind of give voice to some of those experiences to inform what I think is a really going to be an important, pressing set of policy determinations that will be happening over the next few years with respect to the judiciary. I want to start by saying that our piece is emphatically not a takedown of remote court. First off, I think almost everyone we spoke to felt strongly that it was critically important that safety be prioritized in the judicial system, and in many jurisdictions, this was, an appropriate way to protect the health and safety of all participants. And so certainly I think this was, reflected a great deal of, agility on the part of the judiciary, which is not always known to be the most agile of institutions. And there have been, real benefits from remote court, particularly in the context of convenience and time saving. And that's not a footnote. That's not a minor thing. We have, for many people, going to court can be a Kafkaesque ordeal where you can, lose a day's pay at work. You can spend, you have to cover childcare, your entire, it can be a very disruptive thing to have to go to court, spend the day there. There's a lot of waiting. People have to come back and forth. You have accounts that, the pressure of having to go back into court, prosecutors use that to push in plea negotiations. Those kinds of dynamics really matter. And for a lot of people, remote court has made it a lot easier and more convenient to go to court, because you don't have to line up childcare. You don't have to take the day off. You can have a more targeted way of interacting in court. And that's been a real benefit. That being said, that's been a real benefit for people, one, who have access to technology. And we've seen, one thing that's come out very strongly in a lot of the conversations and research that we've had is that the digital divide has been a real issue. That's something that runs on lines of income, lines of race, lines of disability. And so, it can be a game changer, but it's a game changer for those people who have ability to access remote courts. And also its effectiveness has really varied. It's varied with respect to the kinds of proceedings. So for example, proceedings that involve producing documentary evidence, there's been just a lot of hurdles, hassles in terms of being able to actually share documentary evidence in proceedings. And in proceedings that involve credibility assessments involving witnesses, there are real concerns, both the logistics of that. So we've seen reports, for example, of people being coached off screen as they're testifying. The judge doesn't have the same kind of control over a proceeding, as well as concerns about the credibility assessments. That there's a flattening effect. It can be harder to really do that kind of basic role when you have people. When you have people appearing over screen, or sometimes even just over telephone. And then the last element is that it can be very hard for certain kinds of litigants, and especially self-represented litigants. One aspect that we really focused on this piece, we looked specifically at eviction proceedings, as sort of one lens into how remote proceedings are being experienced. Being experienced during the pandemic. And that is eviction proceedings, overwhelmingly, tenants are self-represented. And, we heard a lot of reports about just the different challenges that self-represented litigants were facing in remote court. One element is just all issues around having adequate, clear notice of exactly how to engage in remote proceedings, not sufficient clarity about even just how to log in, which has led to people, ultimately defaulting claims. And then the other piece is that so often courtrooms or courthouses are a place where people access legal services, either formally being linked to counsel or more informally having various kinds of self-help support that's made available to them. And when people are taken away from the courthouse, I think there's been a real struggle to kind of duplicate that kind of access. And so for a lot of self-represented litigants, the remote court dynamic has been a real hurdle in terms of getting the kind of support that many courts have invested quite a bit in recent years to build up further support for self-represented litigants. And the other thing I'll say is that I think one thing that really struck me with the research that we did is how really small things can potentially make a big difference. So for example, a lot of courts seem to assume that people will be engaging in the proceedings via tablets or computers. And in fact, at least in landlord-tenant court, most often tenants are using smartphones. And so simple things like, how do you look at evidence on a smartphone? Can you read things? Has been a huge hurdle for those to allow those people to effectively participate in proceedings. And so, and another example, as I was saying before, is that the lack of clear instructions, they didn't say in the summons, this is how you log into the Zoom session, has meant that for a lot of people, that was the hurdle that kept them from accessing the proceedings. I'll just say a couple quick more things, and then I want to make sure I leave time for discussion. One is that, and one of the motivations we had for this piece is that I think the benefits of remote court have often been clearer to judges and court administrators than the costs because of where they sit. And, and I think there's some troubling indications that at least in these early days in the pandemic, the legal services representatives of impacted communities have tended to not have a seat at the table. And so have the concerns, both large and small, have not always had sufficient voice. And that's varied. Not every jurisdiction is the same, but that's something that we've seen in many jurisdictions. And another dimension is that we've seen some places where you've seen kind of good rules coming from the state Supreme Court level, but really varied implementation at the local level. So that consultation that might be happening at the higher levels of courts are not actually trickling down into people's everyday experiences in these local courts. And so we conclude with some recommendations about just how courts should be thinking about these issues going forward. And among other things, we urge that kind of broad consultation and stakeholder engagement as a really critical element. Being context specific, both different kinds of proceedings. I think that there's a big difference between having a preliminary conference as compared to an evidentiary hearing, for example. And there should be really different approaches to remote court depending on that context, as well as depending on the nature of the litigants. Are you involving detained individuals? Are you involving self-represented litigants? There needs to be real contextualization in how these policies are implemented in the long term. And then finally, you need to grapple with the digital divide. And, again, that's a place where, courts have taken steps, but I think in a lot of cases it's been inadequate. And in a lot of instances, legal services has been relied on very heavily to really step in and provide sort of basic access to technology. So I think, as I said, I think remote court is here to stay, and I think remote court is promising in many dimensions, but that we need to be attuned to some of these costs that are less visible.
Thanks very much, everyone, for introducing your papers. I want to shift to discussion now, and I'm going to start with a general question about norms. There was a common thread among all the papers in this series, tracing norms, how norms operate and function, structure, and how norms facilitate or block reform. And I'm going to direct this question first at Professor Levy to think through some of the historical examples that we can discuss, and then I'll open up to the rest of the panel to jump in with how norms both interacted with your particular topics and just other ideas you would like to contribute. So Professor Levy, you discussed some prior efforts to reform features of the judiciary, some successful, others not. What role did norms play in these prior efforts, and how did the reform efforts overcome some of those norms? Or, in the contrary, how did those efforts sometimes fail?
Thank you. That's a very thoughtful question. So I'd say a couple things. If we're looking back at history and thinking about various attempts to alter the courts, thinking about, for example, a number of the commissions that were formed. The Harassment Commission in the 1970s is a great example. Right? We have the Freund Commission before that. We have the White Commission in the 90s. A number of those commissions were actually pushing for bigger changes. And so I think maybe that's actually the starting point there. Right. So again, taking the Harassment Commission as an example, they were pushing, for example, to split up the Ninth Circuit. And we know that effort didn't really meet with great success, at least not then. And so that actually makes me think, going back to what one of the panelists said was really the theme here, that there is a little bit more room for some of these smaller changes or changes in attitudes and behaviors, that we might actually get more traction with that. And on that, I'll make one quick point before turning it over to the others. There's a great question about how norms develop and how you can keep them going, right? Obviously, we need to have people who have incentives in keeping them going. That's a huge part of the story. But one thing I would say before that is part of this is actually just making the judges and the court officials aware of the various options on the table. Something that I have been struck by time and time again is a comment that a clerk of court made to me when I first started thinking about judicial administration more than a decade ago. And she said, what we do not know about the other circuits far exceeds what we do know, which I was really surprised by at the time. But the more I study the courts, the more I am actually understanding of that statement. And part of what you realize is that for something at least like what I'm talking about, the way that we treat senior judges, there are a lot of different approaches a court can take, and other courts don't necessarily know all of those options, haven't seen them all been put on the table. So my hope is that with some work like this, which is largely descriptive, we can actually be equipping judges and court officials, right? And so that they can say, you know what, there are some norms that we could put in place, some policies we could adopt in our own circuit that would be beneficial to all of us. And that really could be a useful first step in the right direction.
So I'm happy to jump in just a little bit on how norms played a role in Diva and my essay. I think when we're thinking about courts and harassment, obviously some of the deficiencies are just with the state of the law, the fact that there aren't anti-discrimination or anti-retaliation provisions that apply to the federal courts. There isn't a mechanism for comprehensive information gathering or climate surveys, but there are also norms that facilitate, the world in which we're living now, the norm under which you're not supposed to speak negatively about, the judge you clerk for, the norm under which you're supposed to say like only the most glowing things about the clerkship experience, the norms of confidentiality that arguably extend broader than the actual rule of confidentiality, which is you're not supposed to talk about the business of chambers and how they're deciding cases, in the courts. And I think the fact that we are dealing with norms is in some ways challenging, but in other ways, points towards some solutions. The challenge is, the existence of these norms can seem overwhelming. Like, how am I, an individual, a law professor or a former clerk, supposed to change, this established norm that everyone else abides by, where we don't speak negatively about clerking or judges or criticize judges for behavior that isn't the most egregious behavior we've ever seen, but nonetheless, strikes us as, wow, that looks a little problematic. And I get why that can feel overwhelming, and also cause some people to, choose to kind of not do much at all. But on the other hand, the way norms change is when all of our individual behavior changes. And so when we're dealing with these, again, things that aren't part of law, they're not written down rules, they're just ways that reflect our collective behavior and how we've acted over the last couple of decades. That's how we can individually, make a decision to just behave in a different way and ask other people to join us and try to talk to other people about why it might be worth it, to be more open about their clerkship experiences, be more willing to identify behavior that, again, isn't the most egregious abusive behavior you've ever seen, but nonetheless strikes you as quite concerning because it reflects problematic ideas about sex, race, or another characteristic. And, that's the world that, we can hopefully move to.
So with regards, no, go ahead, Diva.
Thank you, Professor. I'll add to what Leah said here. One of the things that our essay talks about is the role of norms in both the composition of the bench and the composition of the clerkship classes. And the sort of level of power that we give to certain tastemakers to replicate their views and how they gain influence also changes sort of the norm, or it doesn't change the norm of the types of people who become judges and the types of people that end up clerking for them. And so if you think about just the norms around who applies for clerkships and who's encouraged to apply for clerkships, most law students are usually pretty eager to have a relationship with a mentor and sort of parrot that mentor. And it can be easy to over-identify with figures that determine, what options you might have after you leave. So you might be more likely to adopt the views of a white male professor or a professor who is in a position to help students get clerkships. And as we've found, and one thing Leah and I talk about is those professors tend to be overwhelmingly white and male and middle class. And so those norms sort of get assimilated just simply by students who want to make sure that they have the right professors that they talk to and can get those clerkships. But that also leads to assimilation while clerking, because judges also tend to be overwhelmingly white or male and middle class. And so the incentive system is one that replicates a lot of the hierarchies that exist within the profession and the people who can more easily assimilate to sort of these norms and assimilate to these ways of thinking, perhaps not thinking outside of the box that much, or at least not explicitly talking about that. If you do have ideas that maybe are not as mainstream in the legal world, these structures will just end up having ripple effects down the road throughout the profession, because the people who get clerkships sort of have this gold star, they get gold star jobs, and then 10 years later, those are the people that end up being clerks, end up being judges who then hire their own clerks. And so the norms that we sort of allow to continue also continue the hierarchies that exist within the system, and who ends up being a judge and who ends up having the same kind of power years down the road, because tastemakers, these individuals that hold a lot of power, will also gain influence on a larger scale and are likely to hire people who sort of have that same ideology and have that same way of thinking. And so this doesn't quite address the question of how we change those norms, but to think about a little bit, the reason to change those norms is because without changing norms, you're reifying these hierarchical structures that don't just operate sort of in obvious ways, but in ways that might cause law students or law clerks to sort of not speak out or even assimilate their views. Although I know that many law students and clerks are more thoughtful than that, but it still happens.
So this idea of norms this discussion is really fascinating to me, because I think here we're in some respects attempting to disrupt norms. But we've actually just finished a period in our country where norms were disrupted in a way that was I think that some people found to be not productive. But for here with regards to this particular piece that I worked on, I think that there's often been a sense that if the person was willing to go away, that we should just allow them to go away. And what is the point of dragging their name through the mud or dragging them through an investigation if they're no longer on the court and no longer at harm to the judiciary? And I think that we have, as a result of Me Too, and even I think the Black Lives Matter movement, we've come to realize that some of us have come to realize that understanding somebody's experience and airing that can have its own set of benefits. One, in allowing that individual to know that their voice has been heard. I mean, that's also a theme within these papers, right? Making sure that potential victims' voices have been heard, making sure that potential complainants' voices have been heard, making sure that senior judges' voices are being heard, and like that they're not going to lose their voice if they decide to take senior status, making sure that litigants, right? So litigants' voices are being heard in different court proceedings. I mean, so when you just allow someone to step down, what you've done is you've taken away somebody's ability to voice their concerns, or for their ability to believe that that the voice that they attempted to provide was heard. The judge that I clerked for, one of the things that he thought was really important, he always would say to us, this case involves a real person, and that real person should know when this opinion is published, that their claim was heard. And so even if we're just affirming, even if it's just an affirmance of the district court, that person needs to know that their case was heard. And I think that there's a corollary here when you have a complaint that's been levied against a judge, just as it would be in more formal legal proceedings. And so I think I understand the norm of allowing someone to retire with dignity, but I think that it is just as important for us to disrupt that norm and to create a new one that says that people who have complained should have there should be its own norm that valid complaints are fully and freely investigated and resolved. There's also a benefit to that, right? So to a certain extent, I think that there's been an education that has surrounded some of the social movements in this country over the past few years. And that education is really important in making sure that similar mistakes and missteps don't continue to occur. And so, but without providing information about what has occurred, I don't know that education can happen. And so, anyway, so I think I'm actually working on another piece about how not adhering to norms is not good, but I'll just let that go. But norms can be good or they can be bad. And I think that it's important to use them as you can, and legal interventions when that seems appropriate.
I'll jump in to speak a bit about norms with respect to the remote court work we did. I mean, I'd say one of the big norms that I touched on a bit in my earlier remarks is that, judges and court administrators spend a lot of time talking to other judges and court administrators. And I don't want to overstate that. I think that courts have made a lot of progress in recent years, the creation of various access to justice commissions. I think there has been, a kind of deliberate effort to, kind of expand that circle. But I also think that what we saw, over this past year does just sort of show how strong that norm is. So just to give a sense, the National Center for State Courts, which is a kind of pseudo-judicial think tank body, did a fantastic set of webinars. They did 34 webinars over the course of last year directed towards courts on steps you could take to address the pandemic. So a lot of that focused on issues around remote court, but just other things as well. And of those 34 webinars, half of them the panelists were entirely judges and court administrators, and only 4 of them had any representatives from civil legal services or public defenders. Similarly, several courts created commissions to help guide their thinking on kind of both the transitions during the pandemic and then eventual reentry. And 12 of them had lists that were published online, so you could see who the members were. And of those 12, again, overwhelmingly the representatives were lawyers, court administrators, and only 2 of them had a representative from civil legal services. None of them had representatives from the community. In fact, the only non-lawyers on those, a few of them had non-lawyers who were kind of public health experts. That was the only representation of non-lawyers at all on those commissions. So I think that just sort of shows, these are examples of how that norm can play out. And I think one thing we tried to do in our paper is kind of highlight the consequences of that when you're not kind of hearing those on the ground concerns, that can have real implications for access to justice and fairness in court proceedings. And in terms of how to disrupt those norms, I think it requires being very deliberate. So in this case, I'd say being very deliberate about participation. And I can give one concrete example. In Michigan, one legal services provider that we spoke to had recounted actually a fairly positive experience with respect to consultation. And what she said was that, the Michigan Supreme Court, the Chief Justice, had issued a directive to the lower courts requiring them to consult with, to have a consultation with civil legal services in the context of the transition to the pandemic. And having that initial meeting really opened the door to a much more fruitful, kind of longer term set of communications and collaborations. And so it's an example of how, targeted interventions can, at least when you have the right people involved, can actually shift norms over time.
Thanks for all of those answers. I think I want to come back to Professor Root Martinez and ask a more pointed question about norms and accountability. I think oftentimes increased accountability and transparency are seen as threatening to judicial independence. And I'm wondering if you could speak a little bit to how to balance those two, I don't want to call them norms, but expectations that we have in our judicial system and wanting to maintain credibility.
Right. So one of the concerns that you hear in this space anytime you talk about putting some sort of restraint on Article 3 federal judges is a concern about who's going to do that, and is that going to create a separation of power concern? And I think it's important to remember that at least in the United States, judges are typically lawyers and are typically members of a legal profession, and we are members of a self-regulated profession. And there's some mimicking there under the Judicial Disability and Conduct Act by allowing judges to discipline themselves, and that can be good. But what I like to remind my students when I'm teaching PR, I actually said this, I think, earlier this week, is we're only going to be allowed to self-regulate ourselves as long as the public believes we're going to do that effectively, right? And we can look at different instances and different examples. The SEC, like certain provisions of Sarbanes-Oxley and SEC disclosure requirements for attorneys are an example. If actors don't believe we're self-regulating appropriately, someone is going to intervene and do it for us. And the judiciary is the same way, right? So yes, there are separation of powers concerns. But if the judiciary is running amok, Congress can come in and impeach people, right? And that we might not like that idea, but there has to be some sort of check. There has to be something in place to check people's power, because if there is no check on power, then the end result is often not positive. And so I think that you have to keep that in mind. I mean, we have one question from the chat that's about, well, it's great if you do things that are regarding the federal judiciary, but what about the states? And that's a place I think where norms could be helpful, right? So if we see that a bunch of federal judges are being able to engage in certain conduct with impunity, then why would state court judges feel any sort of restraint, right? Like that would have an impact on a variety of different ways, like maybe how we think about judicial ethics codes and all sorts of things. But if we ramp certain expectations up within the federal judiciary, one might expect that that's also going to have an effect through norms on other courts as well. I'll stop there.
If I could just add something as well, because there's another question in the chat about, well, how do you protect people who, report harassment from retaliation, given that bringing lawsuits, if you are retaliated against, can actually be quite difficult and expensive and, hurtful to someone's career. And I think there are preventative steps you can take before it comes to that. One is what some people sometimes call bystander intervention. So when someone is harassed, if other people around them speak up about how the behavior is inappropriate, it makes it more difficult just to retaliate against the one person who was harassed or was on the receiving end of misconduct, like if more people in the workplace are speaking out against it. And second is, I think this is an instance where individuals need to be proactive and make sure, not just in the moment, but 6 months, 9 months, a year, 2 years, 3 years, 5 years, 10 years after the fact, like the person who experienced misconduct or reported it, like they are still flourishing successfully. Like we should be looking out for ways to amplify the voices and careers of people who experience misconduct, like not just because of their experiences with misconduct, but because they are also really talented lawyers. We should be trying to provide professional opportunities for them. And again, just to make sure that they are getting the encouragement and resources and support they need to succeed professionally while also having to deal with the misconduct.
I'll also add that the independence of the judiciary is obviously important, but I think I'd question a little bit what people say, because I think people mean different things when they talk about an independent judiciary. And there's a reason that these legal remedies exist in almost every other employment context. So it is a bit odd that the judges that are deciding those exact cases with those exact statutes would not, would lose their independence somehow if those statutes were to also apply to them, when judges themselves are interpreting these statutes in the first place and would be interpreting those statutes with regard to each other. And so I'm not sure how much of the independence of the judiciary is really lost in sort of these larger changes, but also when it comes to retaliation, I echo what Professor Root Martinez said here. It's hard to say that people will regulate themselves and just believe that. And we don't believe that in almost any other employment context. We don't say, well, as long as you like the language of Title VII and the ADA and you show us that you're thinking about it, we're good with that. And so it's a little bit hard to say that, self-regulation is the way to go, even when we value the independence of a certain body.
So I think keeping an eye on the clock, I'm going to do just a quick round robin, everyone jump in for maybe a minute or two, and I'm just going to invite you to offer any closing thoughts on norms or maybe larger structural changes that we haven't gotten to, and the federal judiciary and all the way down to state and municipal courts' role of serving the people. Or if there's anything else you would like to plug, work that you would like to mention that you are now working on. I just want to really open it up, but also offer a few things to jump in on. And rather than picking on someone, I'm just going to let whoever wants to jump in first do that. Or maybe I should have picked on someone. Go ahead.
I'll go first. So I'll just say, the one caveat I will say to my remarks is that I think it's worth noting that the judiciary has been taking action to think through appropriate responses for places where they have been made aware that there are gaps, and that in kind of the policies they have and protections they have for employees. And so I think it is worth noting that there are judicial working groups from this as requested by Justice Roberts and being done in various courts of appeals, and they are experimenting in slightly different ways what sort of protections they should put in place. That is a good thing, but I think that I think that it's important to give credit where credit is due, because I think a lot of different people are working on these issues and have spent a lot of time on these issues, and I don't know if they're getting enough credit for that work. That said, I do think that there is room here for congressional intervention, and so that there's standardization across the circuits and across the courts. And I think that it's an area that that should be welcome in a bipartisan way, to think through how do we promote better equity within the courts.
The thing that I would say is, again, bringing it back to more like the individual personal responsibility level, is to get comfortable and practice saying things like, what did you mean by that? Or I'm sorry, what was that? And just being okay, kind of learning how to say those things, including to people you like and respect, and including people you work with and work for. And second, and relatedly, is learning to get comfortable with the idea that good people, people you respect, people you like, will make mistakes, and they're not perfect. And it has to be okay, to be able to say to someone, I actually think we probably could have handled that a little bit better. Can we talk about what might happen next time, or how we prevent that from happening again in the future? I'm not perfect. It's okay. Then people tell me, you probably could have handled that differently. And I think we could all, do better to learn to become comfortable having those conversations with people we like and respect, and also with people we work with and work for.
I can jump in just to say, I think court reform is having a moment, and that is fantastic and long overdue. In terms of just sort of more broadly, some of the work that we've been thinking about, myself and other folks at the Brennan Center, I'm gonna give a couple plugs. We actually did a convening last week that DIVA, among others, participated in, looking at issues of both law clerk diversity and law clerk hiring, as well as sexual and other forms of harassment in the judiciary. So I think check out our website. There's a really interesting discussion there that dives into some of these issues. I also just put out a short piece today talking about Supreme Court reform and kind of lifting up certain proposals that I think haven't gotten enough attention. I've been very pleased to also see some attention given to the lower courts. I know Marin mentioned that there was a hearing last week. She was too modest to note that she was one of the people that testified at said hearing, but I think it's a really critical that we're seeing kind of that attention on these issues. The only thing I would add is to not sleep on state courts. 95% of all cases are filed in state courts. They're how much most people touch and are touched by our judicial system. And, I think often I think when we think of the courts, like our minds often go to the federal courts, and particularly the U.S. Supreme Court. And there's good reason there, but there's also a real need to look closely at state court experiences. And I'm glad that this conversation has touched on some of those dimensions as well.
I'm very happy to follow up on Alicia. I think absolutely court reform is having a moment in the sun, and that is really exciting. I would say I've been fortunate enough to be in this profession studying judicial administration for 12 years now. And so much of the kind of work that many of us have done has been focused on smaller interventions, in part because the thought has been in the past, that's the only way we're going to make progress. And that's, really exciting work. And a lot of it takes real digging, and it involves doing qualitative work where you're talking to folks in the judiciary and you're learning about the kinds of smaller changes we can make. I think there's real value to that work, even when it isn't, I think, sort of headline grabbing, sexy work. All that said, I think it is tremendous that at this moment we are actually looking at the contemplation of something bigger, that we might actually see, for example, new judgeships added at the district courts where they are desperately needed. And I think potentially even at the courts of appeals, where I would argue they are also needed. So again, while it was, it's been thrilling to do this kind of work for Northwestern, and I do hope it helps the judiciary. It really is something to be able to stand back and say, we might also see Congress intervening in a very helpful way. And I hope not too long in the future.
One last brief thought from me is, I think that a cultural shift is necessary in how we think about clerkships, and reminding students that clerkships are still a job and that clerkships still have the problems that exist with other jobs. But I'd also like to think about who is actually having these conversations. So it wasn't lost on Leah and I when we were writing our essay that students and recent graduates have been more likely to speak out about some of these issues. For example, the women that I work with now at the People's Parity Project, or Law Clerks for Workplace Accountability. I think about Olivia Warren's testimony in Congress. I think about pieces in the Harvard Law Review, and then especially here with the Northwestern Law Review. Adam and Emily and Sarah and others have provided a real space to have these conversations, both on paper and today. And they're doing the work and the reflection that the profession should be doing. But I think that as a profession, while that seems inspiring at times, it also points out that there are certain groups and certain people who should be having these conversations that maybe aren't, and the weight is disproportionately falling on people who may feel the effects of sort of leading these conversations most. And so I'd like to commend them, but I'd also hope that people are a little more encouraged by reading all of these papers, that many different voices can be a part of these conversations on judicial reform, and that we shouldn't shy away from having these conversations, because the courts are a reflection in some way on all of us, and the way that they work and the kind of justice that's available is a reflection on all of us. And I really commend the law students, especially, that have sort of taken this and run with it. But I'm hoping that it's a signal to all of us that we can play a larger role.
Well, on that note and call to action, I want to thank all of our wonderful panelists for participating today. Ms. Bannon, Professor Levy, Professor Littman, Professor Root Martinez, and Ms. Shaw, for all of your really inspiring work in these essays, but also for this discussion today. Thank you to Northwestern Pritzker School of Law for helping host this event and the awesome tech support. But especially, I personally want to offer my own thanks to outgoing Editor-in-Chief Adam Sopko and Deputy Editor-in-Chief Emily Ross for organizing this essay series and for putting this law review live together. I'm just so honored to follow in their footsteps, and I'm very inspired by the work here and the organization. And you all are. Thanks everyone for attending and participating. It's been such a pleasure to be a fly on the wall during this discussion, and I hope you all have a great weekend.